one of the other things that happened on Friday was also substantial. And that's what we're going to discuss today with our guest, Advocate Natasha Hausdorff, barrister, international lawyer, and the legal director of UK Lawyers for Israel. Natasha, thank you for joining us.
Thank you so much, Maurice. I serve as a legal director of the UKLFI Charitable Trust, which is important because the focus of the Charitable Trust is on combating anti-Semitism and also crucially educating about issues to do with the law in relation to Israel, in particular international law. And that's extremely pertinent to the discussion that we're having now on the ICJ advisory opinion.
Without question. So that's exactly what we're going to discuss, is the ICJ advisory opinion handed down on Friday afternoon, ending the reading just an hour before Shabbat. I don't believe that any of this is coincidental. They know exactly that Shabbat will be coming in. They know exactly that the time that the Jews will have to respond to the decision is much limited. And so on Friday afternoon, they hand down the decision. This is just for our viewers, Natasha, this was an opinion asked for by the General Assembly about a year and a half ago. They had the first hearings at the beginning of the year, January, February, and they've now concluded their work and presented their advisory opinion. So the question that they posed there really was, I'm paraphrasing because I don't think it's worth getting into the whole definition. What are the long-term effects of Israel's illegal occupation of the Palestinian territories, and what should everyone around the world do about that? So what did they actually suggest, Natasha? What did they decide when they're talking about, just as a general, when they're talking about the Palestinian territories and the occupied Palestinian territories, what are they referring to? Because I tried to find on a map, well, where were these Palestinian territories? Where did that state of Palestine ever exist that we could occupy them? What were if they're talking about Judea and Samaria and Gaza, well, what was their status between 1948 and 1967? Were they also then occupied territories when they were controlled by Egypt and by Jordan? How did they define those Palestinian territories?
Well, there's a lot to unpack just from your introduction there, Maurice, but you're absolutely right that this is an opinion that was requested by the General Assembly in GA Resolution 77247, which was passed all the way back in December 2022. It was requested, it was put forward essentially by 32 states, 3/4 of whom have no diplomatic relations with Israel, and many of those who don't even recognize the state's existence. So the framing of the question in and of itself was plainly politically motivated. And you're right that it certainly asked the court to presuppose violations of international law by Israel, and it simply asked the court to opine, to give its legal opinion on what the legal consequences of those violations ought to be. So the starting point that the court was intended to adopt as a given, that Israel is a violator of international law, that Israel has violated in particular the Palestinians' right to self-determination, is extremely problematic. And the question really remained as to whether or not the court would simply embrace these presumptions or exercise any fact-finding or legal analysis function about the violations themselves that were alleged. And what we saw was that the court, on the one hand, suggested it didn't need to engage in a fact-finding process at all. It was just making legal assessments here. It then purported to find facts in accordance with information that it suggested had been put before it, repeating a problem, a grave mistake and miscalculation that the International Court of Justice also conducted in respect of a previous advisory opinion against Israel, the 2004 Wall opinion, which was severely criticised for similarly proceeding on an incorrect factual basis. In that opinion, making an assessment of Israel's security barrier, it failed to even recognise the reasons behind the building of that barrier, namely the waves of suicide bombings and terrorist attacks that Israel was suffering. And that was all the way back in 2004. Fast forward to this subsequent advisory opinion, and again, we have no mention of Palestinian terrorism. They specifically ruled out events post the 7th of October, or even including the 7th of October, rather conveniently. And they proceeded in adopting these false allegations of violations of international law against Israel to opine on what should follow, including the evacuation of settlements, read there, the ethnic cleansing of Jews. But you're right that it was able to do so on the basis of finding this nebulous occupied Palestinian territories that it didn't completely define, but it did go a substantial way towards it when it called it contiguous. And in that respect, very much seemed to wipe Israel off the face of the map. Anyone that is familiar with the cartology of the Middle East knows, of course, that the Palestinian-controlled territories, which are controlled as a result of the Oslo Accords in the West Bank, which created the Palestinian Authority with authority in areas A and B, and then subsequently, of course, in 2005, the withdrawal of Israel from Gaza. That didn't factor so much in the court's reasoning or analysis when it purely purported to find that there was such a thing as Palestinian territory. And it seemed very much to rewrite history when it did this, in suggesting that there was a Palestine before the creation of the British Mandate. And albeit it's not explicitly set out, this is another big fudge by the 14 justices and the majority of the court. It suggested, I think, through that tracing of its revisionist history, that there was a Palestine before the British Mandate, which might in some way be regarded as Palestinian territory. And it is opined essentially on that alternative factual basis. So many problems with the way that it has approached certainly the factual matrix, but separately, its purported application of international law has made leaps and bounds on accepted international legal frameworks, in particular the framework of the law of occupation. It seems to purport to suggest that occupation has in some way applied to Gaza, even after the 2005 withdrawal, albeit the analysis for this is sorely lacking in the context of the majority's decision or the opinion that it's put forward. But we also see, I think, very worrying omissions. Omissions as to fundamental aspects of the analysis of the status of the territory, something that is remarked upon, I have to say, in an admirable, extremely detailed, robust dissenting opinion by the vice president of the court, Julia Sebutinde, who also factors into her own analysis the doctrine, the rule of customary international law of uti possidetis juris, which is integral, central to analysis of the very status of the territory that this opinion is said to attach to.
Explain that. I apologize, Natasha. Explain that principle to our audience. It's fundamental to understanding because it really encompasses where are Israel's borders as opposed to any other state. And really that principle is part of the fundamentals. So I apologize for interrupting, but please just explain exactly what that means.
Certainly. This is a rule of customary international law that developed over many, many years. It was recognized by the International Court of Justice as having emerged after it was first applied in the 19th century in South America at the withdrawal of the Spanish. It was applied there to avoid a vacuum occurring at the withdrawal of the colonial power, or a terra nullius, as the court referred to it. It was later applied in Asia and in Africa, and at the dissolution of all the communist federations. And it was also applied in the context of states emerging from mandates. And this is something that Judge Sebutinde refers to explicitly in her dissenting opinion, that this is the rule that applied by default to states that were coming out of a colonial entity. And the rule states that the newly emerging state inherits the pre-existing administrative lines of whatever unit as its internationally recognized borders, bar any agreement to the contrary. The rule was said to have developed out of a need to provide stability and certainty and to avoid fratricidal struggles between states. There is no argument that I have seen advanced in the last 10 years that I've been dealing with this issue to explain why it for some reason oughtn't to apply to the creation of the State of Israel. This was a state that was declared by David Ben-Gurion on the 14th of May 1948 at the withdrawal of the British from the mandate. It was the only state to emerge from the mandate, and under this rule, it inherited the pre-existing administrative lines that included Gaza in terms of the border with Egypt, and it also included East Jerusalem and the West Bank, Judea and Samaria, in terms of the border with Jordan. Now, that's significant because it speaks to the underlying status of the territory. What happened then, of course, immediately after Israel declared independence was a war of annihilation was waged against it by neighboring states and the local Arab population. And Jordan occupied East Jerusalem and the West Bank and ethnically cleansed it of its Jews. And likewise, Egypt occupied Gaza. When Israel recovers that territory in 1967, this is a war, another war of annihilation that was waged against Israel, but the court simply refers to the fact that war broke out in 1967, spontaneously, it seems, another rewriting of history, if you will. But in the course of that war that Israel fought, again for its existence, it recovered East Jerusalem and the West Bank from Jordan and Gaza from Egypt. Now, one fundamental principle of international law is its equal application. You cannot have a general rule and then an exception for countries that you don't like very much or you have some ideological or political opposition to. This universal rule of customary international law dictates that Israel recovered its underlying sovereign territory from those states that attacked it. We don't need to go down, acquisition of territory in defensive wars. We certainly don't need to analyze concepts of annexation because you cannot annex what is already your own sovereign territory. And if we compare it to other cases, other examples in international law, I mean, one extremely well-known one at the moment is that of Ukraine, whose borders also followed the rule of uti possidetis iuris, and that is why there is a general consensus that Russia has occupied Crimea from Ukraine. Now, if Ukraine were to recover Crimea from Russia in the course of the current war, nobody would accuse Ukraine of occupying Crimea from Russia because it's clear it was recovering its own underlying sovereign territory in the same way that Israel recovered those areas, these disputed territories now, from Jordan and from Egypt. All of that is fundamentally significant as I think the only sensible application of international law to the establishment of Israel and the borders of Israel. It's also underscored by every single agreement that has followed. So the armistice agreements, which were explicit after the 1948-1949 war, explicit agreements with Egypt and with Jordan that did not recognize any borders, and those states refused to recognize any borders because they also refused to recognize any legitimate Israeli presence in the entire region. But what those armistice agreements did is that they referred back to the mandatory lines. The subsequent peace agreements with Egypt and with Jordan also, when they finally did ratify borders, did that according to the pre-existing mandatory line. So there is no argument that I have seen advanced to counter this fundamental rule of customary international law and its application to Israel as clearly stated in the dissenting opinion. The fact that the court refused to deal with this at all is plainly inexplicable. Deeply shameful. But there's one additional aspect here, which is that the 14 judges that signed on to the majority opinion put forward a patent falsehood about the information that they had to determine claims by Israel to the territory. So the core issue here, which is the status of the territory, and they claim that there simply wasn't any information before them. Now, that is palpably untrue because of the number of submissions that were made under Practice Direction 12 from international organizations, but also from states like Fiji that put this position there before the court plainly and clearly, and has certainly been picked up by the dissenting judge. So there is issue upon issue to do with the factual and legal analysis or pseudo-analysis that the court is engaged in, which undermines any value in this advisory opinion. And it's important to clarify that this is not a decision by the court, this is not a ruling by the court, it is simply an advisory opinion that is not legally binding. And I would suggest that the status of it and its value can only be properly assessed by the merits of the analysis that it puts forward. And these are just some of the instances in which the court has abjectly failed. There are many people who have called out the president of the court and his vicious track record of anti-Israel sentiment, deeply anti-Semitic in some respects in terms of his previous role as ambassador for Lebanon, of all places. Of course, he is the Lebanese judge on the court. To the United Nations, and comments that he's made in the context of accusing Israel of terrorism and other war crimes. The idea that this court is made up of impartial judges is pretty laughable at this point.
So I don't understand that, Natasha. I hear your what you've argued, and I hear the legal principles that you're arguing, and I hear the court saying that they didn't have any other information before that. I don't understand. Is the court's a part of the UN? It's one of the 6 arms of the UN. One of the fundamentals of the UN is the mandate, the League of Nations, as adopted by Article 80 of the UN Charter. What more basis do they expect to find that someone will come and say, oh, by the way, the sun is shining today? How could they have ignored such basic facts that are UN decisions, UN adopted decisions, to really just distort the reality, to assume that history begins almost on the 5th of June 1967. There was nothing that came before that. There were no UN decisions before that. There wasn't a genocidal war waged by the Arabs against the nascent Jewish state. How can 14 international lawyers in a court that calls itself the International Court of Justice be so blind and oblivious to what clearly is basic fact, basic law that has to be interpreted in an unbiased and objective fashion? This would seem to make the court just to be another political arm, basically, of the PLO.
I find it difficult to argue with what you're putting forward. You make also a very important point. I've analysed what the judges have said in relation to the information that they have before it, and shown you that that's simply not true. It is plainly inaccurate, because we have, as a matter of public record, copies of the information that the court had before it, the argument certainly, and the factual details, and those are also referenced in the dissent. But I think the point that you're referencing is a much more elemental one, which is that anyone with basic literacy should appreciate the historical, factual, legal basis to the underlying claims that Israel has to the territory. Now, this is critical to make a distinction here. That starting point, that the status of the territory has been sovereign Israel since 1948, since its declaration of independence, what the court previously referred to as the snapshot of the territory at the critical date, that doesn't in any way prejudge what a political resolution ought to look like. And the fact of the matter is that when Israel recovered that territory, it didn't apply its law, administration, and jurisdiction in full to the West Bank, say, in the same way that it applied it to East Jerusalem. When it did that, it's important to note that Abba Eban, who was the foreign minister at the time, wrote to the UN Secretary General and explained that this application of law, administration, and jurisdiction to East Jerusalem did not constitute annexation. Again, I would read there, one cannot annex what is one's own sovereign territory. But what Israel did with respect to the rest of that territory that it recovered is apply a temporary administrative framework. And that temporary administrative framework, which was supposed to last until a peace agreement with Jordan, where under the Land for Peace formula, some of that land would have been given to Jordan in exchange for peace. Well, when the peace agreement rolled around in 1994, Jordan didn't want anything to do with that territory. So that temporary administrative framework has remained in place. And it's correct that that administrative framework brings with it, has borrowed aspects of the law of occupation to assist Israel's administration and governance of it. That is the false basis upon which it seems that the court and many other international legal institutions before it have presupposed that Israel's status there is an occupier, or that the international law of occupation and the framework of the law of occupation as a whole applies. And that is extremely problematic for many reasons that we probably don't have the time to go into in particular detail. But your suggestion, your analysis that the only possible explanation for such a wholesale throwing the law and the facts out of the window is that this is a politically charged institution now, is, I think, one that's very difficult to argue with. I mentioned the track record of the president. I think it's clear, certainly from information coming out of the court, that he is the one that has been driving this process forward at speed, and has certainly, it's the job of the president in preparing the either orders in contentious cases or advisory opinions to try and bring judges on board and to provide a draft which more or less as many of the judges as possible can sign on to. And there are telltale signs in the majority opinion of fudges that he has clearly engaged in to try and get people to sign on. And I have to say, contradictions between the majority of opinion that 14 of the judges signed on to and some of the separate opinions. For example, Judge Nolte's separate opinions where it's clear that the charge of apartheid against Israel isn't accepted. Well, if you read the majority of opinion, the implication is that it is. So there's an awful lot of aspects here that desperately lack clarity. There will be severe problems, I think, coming out of that. And we've seen the way that previous provisional measures orders by the court in the contentious case that South Africa has brought have been completely misinterpreted, especially by the international media, but by many, many respected lawyers as well. So the court is playing a very dangerous game here. It's playing fast and loose with the law. It's advancing a political agenda against the world's punching bag, the Jewish state. And it is damaging the credibility of international law, and in particular, the credibility of this international legal institution, the International Court of Justice, immeasurably, I think also irreparably. And that's another reason why states that actually care about the rule of law, care about international law being upheld. I mean, I'm sure there are many in your audience, Maurice, who will say, oh, international law, what is it? It's all politics anyway. And I have understanding and sympathy for that law, that perspective. When I was at university a long time ago, and I started studying international law for the first time, I was told by my professors that most states adhere to most international law most of the time. And therefore it is, a net positive. There is a good to be derived from this. I'd expand on that and say that actually public international law, which is the basis upon which states interact with each other, is of huge significance to our everyday lives. It provides the framework of international diplomacy, international commerce. And if this is now being attacked for political reasons, if the general principles of international law that it applies equally are being eroded in this fashion, that has really dire potential consequences, not just in relation to Israel, but in relation to states all around the world that may find themselves similarly targeted by those that support international terrorism.
So really that's part of the general picture of this decision. Not only it's a really internal contradictions, some of like the glaring mistakes that were made, I would argue, in the decision itself, and those then give about, I think, tremendously dangerous, at least in terms of also the local politics, tremendously dangerous repercussions. For example, Gaza is occupied. That's one of the I think the cornerstones of the decision that they made.
It's a little bit unclear. It's something that's definitely been fudged. It seems to talk about occupation in terms of a functional occupation, which is a very new manifestation. It's a manipulation, clearly, of what international law says.
Something new that didn't exist before. Occupation generally required effective control, and what they're trying to argue is that, well, Israel had effective control over the Gaza Strip, so we could have prevented Hamas from building up a 40,000 strong terrorist genocidal army. We could have prevented Hamas from digging 600 kilometers of tunnels under the Gaza Strip. We could have prevented Hamas from importing from Iran via Egypt and the tunnels and tens of thousands of explosive projectiles. This idea of effective control over Gaza is, as you said, so beautiful. It's just one of those questions that have been fudged. And now they say that as part of that, that it's obviously Israel collecting taxes for that area. I mean, that's just a fundamental lie. From 2005, since Hamas took over, Israel has continuing collecting some of the taxes as part of the Oslo Accords. But even the Palestinian Authority, Mahmoud Abbas and his cronies have admitted that Hamas independently collected its own taxes, even import taxes on goods that came in from Egypt, and had nothing really to do with Israel. So factually, what they argued was fundamentally wrong, and yet they seem to have taken that on to that very easy step, saying, well, there's no difference between Gaza City, which is occupied, never mind the details, and Jerusalem, the Temple Mount, which is also occupied. That's, I think, one of those subjects which they really did, as you say so clearly, fudge all the way along. That there's no differentiation between any of these areas. Everything is the same. Gaza, Ramallah, Jerusalem, the Jewish quarter in Jerusalem, it's all Palestinian territories.
There are quite a few internal inconsistencies in the majority of opinion as well. One of them I think you've just alighted on. So in respect of Jerusalem, it actually refers to Jerusalem as a corpus separatum, which was originally the UN's intention for it. Under plans that were rejected, that were never implemented. This was a recommendation by the General Assembly. It has no political, it's a political measure. It has no legal status. But on the one hand, the court suggests that Jerusalem ought, on that basis, to be considered a corpus separatum, and therefore an Israeli presence in it is unlawful. And in the same quite the same breath, because it's on a separate page, but in the same opinion, it's also put forward that this is Palestinian occupied territory, Palestinian territory that is contiguous. So there's an awful lot there that simply doesn't add up. And I think the reference that you have just made to control of Gaza, which is plainly incorrect, that comes from many reports that have been put forward to the court by UN bodies, including a report from the UN Secretary General that includes hosts of inaccuracies and false material, but the court has taken this as a given, and in so doing also given it a judicial stamp of approval. So I would, don't hold your breath, because I think these reports are now going to be deployed in other contexts on the basis that they've been taken to be the received wisdom, honest truth by this politicized court. But it's also important to note that the court's decision to say we're not going to consider what has happened since the 7th of October in terms of Israel's conduct in Gaza brings with it the refusal to acknowledge what you have just said, that Hamas has been in total control of the Gaza Strip since 2007 and its violent takeover, that it has built up its terror infrastructure there, that it has smuggled through these tunnels that have been discovered now on the border between Gaza and Egypt at Rafah, munitions, material to build up its terror infrastructure, including these tunnels, despite the properly approved restrictions that Israel was enforcing on concrete for tunnel building and other dual use items and military equipment, something I have to say that the UN has recognized as lawful, the quote unquote blockade that Israel has instituted, which doesn't, of course, attach to humanitarian provision, but does properly seek to prevent Hamas from building up its military infrastructure. That has been acknowledged previously as entirely lawful by the United Nations. So the level of internal inconsistencies and the cherry picking of information undoubtedly has had a significant impact on this. There's one aspect which I think is critical to highlight that comes out of that, in terms of cherry picking previous resolutions of the United Nations and endorsements by that body. And that concerns the Oslo Accords. Now, not only is the Palestinian Authority's lawfare activity in this case and in others completely contrary to its obligations under the Oslo Accords, its breaches of the Accords are perhaps less surprising in the context of its lawfare activities immediately after it was signed in the context of the Second Intifada. You know, the primary requirement under Oslo, which was to renounce terrorism, was never adopted, embraced by the Palestinian Authority. But these activities at international legal institutions to change the status of the territory unilaterally, not through bilateral good faith negotiations between the parties, the Palestinian Authority and Israel, as adopted, embraced by the international community as the only route to a negotiated solution. The Palestinian Authority's flagrant violation of this, throwing the Accords out of the window, is one aspect of what the court has endorsed. But the court's also just thrown out the entire Oslo framework, which has, as I said, been internationally adopted and approved. So these international agreements are clearly not worth the paper they're written on. There is no incentive for Israel to engage in negotiations with an entity where the international community is saying we're giving them all the cards. There's no reason for the Palestinians to enter into negotiations because they've just been given, as far as they're concerned, the full house. All of this has a dire, desperate, necessary consequence, repercussions for the prospect of there being any negotiations. Now, you may tell me, well, there was no prospect of that anyway because the Palestinian Authority refuses to renounce terrorism. It's continuing to pay the salaries of terrorists. It's continuing to indoctrinate children from kindergarten level up to hate the Jews. What is there to negotiate in that context? I wouldn't argue with that, but I would also say, from the international community's perspective, the fact that this opinion has passed without international outcry, that their own efforts to secure negotiations and the supposed negotiated solution here have been completely trashed by the court. That's something I hope and expect to see responsible nations that were committed to the Oslo process at least questioning in the coming days, weeks, months.
So I think that what you've just now pointed to, Natasha, is probably, I think, the longest standing and most offensive part of the decision made by the court. If I were to put myself into the shoes of any future Palestinian leader, let's put Mahmoud Abbas aside, how could he ever come to his people and say, I've come to an agreement, to a negotiated settlement with Israel that doesn't include everything that was just given to him by the court? A complete ethnic cleansing of Judea, Samaria, Jerusalem, Gaza, everything else. That is what the court just did. The court, I think, not only instructed Israel what to do, but has now completely handcuffed any Palestinian leadership into a position that even for them is untenable, that they'll never be able to realize. But on the other hand, they have their own political base to support, their own people to explain their decisions to. And well, the court gave us everything in the same way as UNRWA for the last 75, 76 years has promised, falsely promised, the return of all of the now 6 million plus refugees to Israel to destroy it. This decision, I think, will be waived by every single Palestinian leader as saying, you know what? Firstly, even when we did negotiate with Israel, the court came along and said, you have no standing to relinquish any of these inalienable rights. And even if you did agree, we're negating those agreements. And secondly, this is all yours, and you cannot give up on any 1 centimeter of it. Now, that's more akin to the charter of Hamas rather than it is to an international legal establishment. But really, that's what the court said. Never mind what they said to Israel. Never mind the bulldozing of international law. What they just did really is to completely bind almost forever any potential Palestinian leadership.
I think that analysis is spot on. Despite the fact that this is not an opinion that has binding force in international law, it's extremely powerful in binding and hamstringing the Palestinian leadership.
Exactly.
So even if, and Abbas now in his 19th year of a 4-year term ultimately will be replaced, even if there were to follow an individual that actually, for the first time in the history of the Palestinian leadership, wished to engage in good faith negotiations, wished to come to some sort of solution, I think you're absolutely right. They are completely hamstrung by what we have seen handed down on Friday. Significant, I think, that again the court is delivering some form of judgment in relation to Israel on a Friday afternoon. This cannot be a coincidence, and the ability of many of our colleagues to engage with the substance of this over the course of Friday night and Saturday has, of course, been extremely limited. Likewise, we've seen the way that it's been reported. Many media outlets misrepresenting this as some kind of ruling or decision, and suggesting that this is now the final word on settlements, on the quote unquote illegal occupation, and on the requirement that Judea and Samaria be ethnically cleansed of Jews. It's never really been clear to me that there has been any incentive on the Palestinian leadership to seek a peaceful solution, and the international community is significantly to blame for that. First of all, by putting forth unrealistic expectations, as they have now doubled down on in the context of this advisory opinion, but also because of the practicalities. When you consider that the only thing preventing a Hamas takeover of the West Bank, in the same way that they took over the Gaza Strip, throwing their opposition Fatah members off the roofs of buildings, is the Israeli security cooperation, which is provided to the Palestinian Authority. When you consider that Abbas also relies on international donations, which flow in as a result of the perpetuation of the conflict, or that the perpetuation of the conflict is central to his own hold on power. Why is it that they continue to indoctrinate kindergarten kids to believe that the highest calling in life is to become a martyr and slaughter as many Jews? Because the perpetuation of Israel as the outside enemy, or the Jew as the outside enemy, helps, just with any despotic leader, any dictatorship, helps them consolidate their own power, because any problems can be blamed on that outside evil entity. When you consider all of these, that the case for realistic peace negotiations has never been a strong one, but it's perfectly fair that this opinion has taken the legs out of whatever remained for it.
So I would actually argue that to its nth degree and say that this decision really has killed any real possibility of a negotiated settlement between Israel and the Palestinians, because it reflects maximalist demands by the Palestinians that are meant to be then negotiated and discussed. And here they've been set in stone almost. And I think on that level, it's important for our audience to understand that whether you call this a judgment with final and binding force, or whether you call it an advisory judgment, really does have little bearing on the Palestinians and the Palestinian mindset. They see this as an expression of, well, this is what international law reflects. This is what 14 out of 15 judges on the International Court of Justice said. This is what the legal arm of the UN said. And therefore, their ability to then take any other course is completely eroded and negated, because they don't have that ability to say, well, you know what we've been arguing all this time simply wasn't true to start with. And now that it's been set in stone, now we're even more locked into that same position. And so whilst maybe the I won't call it minutia, but really the fine understanding of the legal value of this decision, of this advisory opinion, may possibly be argued, for the Palestinian people, for the Palestinians hearing it, it is a decision of the highest court in the world and has to be followed. And I think on that level, it's very dangerous. One question for you, which I possibly saw as the positive side of this decision. that maybe I missed it when I was going over it. I never saw any reference to the state of Palestine. This you would think would be really a staple of any decision, that the state of Palestine and its territory is part of what we're discussing. How did the court refer to the state of Palestine?
Well, it didn't, and that's an important point. Whether that is a reflection of the negotiations between the judges in terms of getting 14 of them to sign on to this, or whether it's simply keeping options open in terms of the Palestinian movement and its right to self-determination. Because, of course, if a state of Palestine exists, then that self-determination has arguably been fulfilled, at least on the arguments that we've heard put back and forth in the context of these international tribunals. So it's significant that the reference was to the Palestinian territory, on occasion the OPT, the Occupied Palestinian Territory, and as I mentioned earlier, that this was referred to as contiguous, which had to be preserved and respected. I mean, therein lies the eradication of Israel from the map. And I don't quite understand how their appreciation of maps works, because the Palestinian Authority controlled territory, the territory controlled by Hamas in Gaza, is certainly not contiguous, and there are many Jews living in sovereign Israel in between it. But the impact of this is probably going to be, in terms of the next steps, if we put aside your analysis of what this is doing to the Palestinian leadership, the big question will be, well, what is the international community going to do off the back of this? Because the hope and expectation has been that this provides a framework for a UN Security Council resolution. Now, those are not legally binding either, unless they are made under Chapter 7 of the UN Charter. These are few and far between. One followed the September 11th attacks, requiring all states to take all means necessary to prevent international terror, specifically the funding of international terror. One followed Iraq's invasion of Kuwait. So, I mean, situations of real international crisis. And they carry Chapter 7 resolutions of the UN Security Council, carry legal obligations on states to abide by them. So far, what we have seen are non-binding political resolutions, both at the General Assembly and at Security Council level, in relation to Israel. And the hope and expectation of those anti-Israel actors, those that sponsored the original General Assembly resolution that asked the court for this opinion, are to spin this off into some supposed UN binding resolution that targets Israel, that maybe orders the evacuation of settlers, the ethnic cleansing of these areas. I think then you'll get into extremely interesting territory as to whether a resolution of that nature can in fact be lawful. You know, if it is undermining a state's territorial integrity, if it is undermining a state's right to self-defense. These are fundamental aspects of international law, which are not bestowed by the United Nations. They are not bestowed by the UN Charter. People frequently refer to Article 51 of the UN Charter as giving states rights to self-defense. People should read the article. It says it recognizes the inherent right of states to self-defense. There are certain aspects of international law which are so fundamental, including the expectation, the obligation on every state to protect its citizens, to self-defense, that are not bestowed. They are inherent. They are recognized by the UN. If there are further, even binding, legally binding, supposedly, resolutions that so conflict with fundamental aspects of international law, I think we're going to see lots of discussions as to whether or not they can actually be considered to be legitimate. But this carries with it the disintegration of these international legal institutions, and of international law more generally, which I mentioned earlier is problematic not just for Israel. But watch this space. Undoubtedly, it's going to be integral also to pushing the case against Israelis at the International Criminal Court. This is a court that doesn't have jurisdiction over Israel or Israelis at all. But the same legal acrobatics that the International Court of Justice has deployed, has engaged in with respect to this advisory opinion, that it has engaged in with respect to the provisional measures orders in the contentious case that South Africa has brought alleging genocide, that that UN bodies have engaged in, that the UN Human Rights Council, that special rapporteurs of the UN have engaged in, that the Commission of Inquiry at the UN have engaged in. All of this is coming to, boiling point. And the question will be if a supposedly legally binding instrument is brought forward, making these same false allegations and requiring Israel to act in a way which is completely incompatible with its own obligations under international law to Israeli citizens, then we might start seeing real fireworks.
So our viewers know that I try to end these programs really with a little bit of a positive note. And therein you just mentioned, I think, one of the additional positive aspects, as few as they were within the decision. If we remember, the 2004 advisory opinion of the court said that the Jews didn't have the right to even self-defense under Article 51. And this new decision doesn't seem to negate our complete right to defend ourselves against genocidal terrorists. Is that a positive development, or is it just something that they just didn't touch on and they still deny our right to defend ourselves?
I'd say it's something that they didn't touch on rather than something that they acknowledged in all fullness of it. And the acknowledgement is arguably a further fudge, but at least perhaps significant that the reference in that previous advisory opinion of the war, which was subject to so much criticism, which wasn't explicit, but it was a suggestion that the right to self-defense might not apply in the same way against non-state actors. I mean, that certainly wasn't advanced again. The court didn't double down on that false reading of international law as it did on so many others. If you're looking for a silver lining, perhaps that may at a stretch be one, but I would advocate every single person out there to read the dissenting opinion of the Vice President of the Court, Julia Sebutinde. She has displayed from the outset of these proceedings and also the proceedings in the contentious case against Israel, the utmost integrity, intellectual ability, judicial proper approach, both to international law and to the problematic factual matrix that has been put before the court. And she sets out, the real international law that ought to apply and ought to be considered by the court, which is absent entirely from the majority's opinion. She sets it out there in chapter and verse in a breathtaking, concise, but extremely comprehensive fashion. So I can't stress strongly enough that this woman needs to be celebrated by anyone that prizes international law, and her dissenting opinion ought to be staple reading for anyone wishing to engage in a discussion of these issues.
Without question. Unfortunately, Natasha, our time has come to an end, even gone over a little bit. So again, thank you for joining us. Thank you for taking time. And we hope that we will be able to reserve the right to have you back with us again to discuss the next developments. And there will be developments also with the ICC. We'll see where this is going. The next attempt by the Palestinians to re-engage on the subject of genocide, going back to that same question. And maybe we will be able to enjoy your analysis then as well. In the meantime, for you and everyone else, have a great week, and we will see you again on Wednesday. In the meantime, stay safe.